The chief Lawan was actually deposed, removed from office. All the legally prescribed procedure were not followed. He didn't have fair hearing during the course of the investigation by the local government and all the panels, that were constituted. It was just a recommendation for his removal. He was neither invited, to come and make any representation or come and defend himself. That was a clear case of lack of fair hearing. However, the law is that equity aids the vigilant, not the indolent. The law is after 6 months, your matter is statute-barred. You can no longer litigate over the matter. The reasoning behind that, the jurisprudence behind that is so that there should be an end to litigation, so that people will not just flood the courts with cases, some
Anytime
cases
they like.
frivolous, exactly, frivolous cases. 20 years later, you are still filing a case of something that happened 30 years before. So that's why there's a procedure, there's a requirement for you to file within a specific period of time. If you file out of that time, that matter would be statute-barred. And in this case, the law is after 6 months, you cannot file a case against the local government.
Or against
In some cases,
Is
it is
this all
3 months.
cases?
It is 3 months for
Okay.
federal government, state government agencies. 3 months, in some cases they say 6 months, but usually 3 months now. After that 3 months, if you file, except you have something very exceptional, an exceptional ground, rarely will you get the court listening to you. The court will have no jurisdiction. You rob the court of jurisdiction to entertain that particular suit. And that's what happened in this particular case. So equity aids the vigilant, not the indolent. You cannot wait after 7 months. That was when you now wrote a letter. Because you did not get a response, 10 months later, you now sued. You ought to have written that letter within that 6 months. And if they did not respond, you file your case in court. And finally, there's something you call the pre-action notice. You do that, or you serve the federal government, state government, or local government before suing them. There's a provision for that in most of the laws establishing most of the institutions of government. That pre-action notice is to tell them that I am going to sue you for so and so crime or so and so thing that happened to me, and I'm going to be demanding so and so amount of money or so and so amount of damages because of the thing that you've done to me. That one, usually you give them a period of, depending on the law, usually maybe 1 month, after which, if the authority or the institution does not respond, you can now even go to court. So if you do not fulfill this procedure of giving this pre-action notice, pre-legal or pre-suit notice, you cannot even sue. So there are procedures. If you don't follow these procedures or these steps that is required, I'm sorry, your case might just be OYO. So that's why in some organizations, for you, maybe you're in an organization, and according to your handbook, the policy says if this thing happens, you are expected to have exhausted all the internal mechanisms in this organization to resolve the dispute or to resolve the issue. You cannot just go to court straight off. You have to have made sure that you have resolved all of these issues, except in some exceptional circumstances. There's always an exception to every rule of law. But in this case, Mr. Lawan was clearly wrong because he filed his case out of time. He might be right if he had come on time to say, oh, I was removed unjustly, the procedure that removed me, there was no fair hearing. If he had come on time, I doubt if any court would not have listened to him. But because he filed out of time, and because equity is the vigilant and not the indolent, not the weak, not the sit-down look person, not the person who sits like Dodo, the court would always come in aid of the people or the person who is vigilant. And that's why he lost in this case. So pathetic, though.